Many of my misdemeanor DUI cases end up going to jury trial. Most of my clients have never been through a jury trial before, and so before we begin the actual trial, this is how I explain the process to them. Misdemeanor DUI cases in Arizona are decided by a 6-person jury. In order to get the jury, the first order of business in the trial is to pick that jury. To do so, what the court will do is summons a whole series of people, usually, depending on the court, anywhere from 18 people up to 35 people, bring them into the courtroom, and this constitutes the jury panel. Court then asks the jury panel a whole series of questions designed to see if they have strong feelings or another in a driving under the influence case. One of the questions I like to ask is, do any of you have strong feelings about the charge of DUI to the extent that you think it would be difficult for you to be fair and impartial? Now, out of this jury panel, we need 11 people. The reason for that is the ultimate jury that decides the case will be 6 people. One person will be designated an alternate, so that's a 7th. And I have the right to knock 2 people off the panel for no reason at all, and so does the prosecutor. So to get to the ultimate 6, we need 11 people out of the panel. If we are unable to get 11 out of the panel, depending on the court, Phoenix, for example, if we're unable to get 11 people, they usually have extra jurors available, and so we then use the extra jurors to come up with the 11. Other smaller courts, such as justice courts, quite often do not have any extras, and so we're unable to do the trial on that day. Now, once we have exercised our peremptory challenges, those are the ones where we knock off 2 people for no reason at all, we'll end up with 7 people. 7 people will listen to the trial, and right before the jury goes to deliberate, the judge will at random designate one of the 7 as the alternate. After we have picked the jury, the next thing we do is the judge instructs the jury as to what the law is that they're to consider. These are called preliminary jury instructions. These quite often include the elements of the offense, what constitutes driving under the influence, as well as some basic rules on how to listen to the evidence. After the judge has concluded the preliminary instructions, then the next thing that happens is the prosecutor makes his or her opening statement outlining what they think the evidence will show, and then I do the same thing for our case. After the opening statements, the prosecution has to proceed with its witnesses. In a DUI case, these usually consist of police officers, usually the arresting officer and sometimes some other officers, sometimes civilian witnesses if they've observed something, and quite often an expert witness, one who would analyze the blood test results to say what they think they are, as well as in a breath test, quite often they have an expert testify as well as to the operating condition of the machine. At the conclusion of the state's case, then I can make a motion called a motion for a directed verdict, in which I try to get the judge to agree that the state has failed to show any real evidence against my client, and therefore the case must be dismissed. If that happens, that's exactly what does happen. The case gets dismissed. If not, then we proceed with our case. Now, in a criminal case, the defendant is not required to testify. So I will discuss that matter with my client. We'll see if there's something that we think my client should have to testify to. If my client doesn't testify, then the judge will instruct the jury that they can't infer anything or consider that fact against my client, because everybody has the right not to testify. Thereafter, I may have some civilian witnesses of my own to have testify, and in the case of blood tests, sometimes we have an expert witness come in and challenge the accuracy of the state's test, and the same with breath testing. Once my case is over with, the state has the opportunity to do what's called a brief rebuttal, in which they can try to contradict some of the things that I brought up for the first time as a part of our case. After that, the judge will then instruct the jury as to the final instructions, in which the judge will tell them what the elements of the offenses are, the standard by which they're going to decide the case beyond a reasonable doubt, and further tell them that their verdicts must be unanimous on each one of the criminal charges. At the conclusion of the final jury instructions, then the prosecutor makes his or her first closing argument. I then make mine, and because the state has this heavy burden of trying to prove a case beyond a reasonable doubt, the prosecutor has the opportunity to argue one more time without giving me a chance to reply. At that time, remembering again that 7 people have been listening to the evidence, the judge will at random designate one of the jurors as the alternate, and the remaining 6 will go back and decide the case. Now, obviously, what we're hoping for is verdicts of not guilty on all the charges. And if that happens, then we go home and that's the end of the case. If the jury does come back on guilty on any one of the criminal charges, then we will usually proceed directly after the return of the verdicts with the sentencing. If the jury is unable to decide on some of the charges, that's called a hung jury, and it'll be up to the state to decide whether they want to try the case again. So that briefly is the way a misdemeanor jury trial is done as a jury trial here in Arizona.